Let me introduce first, before I start my presentation. I'm an international arbitration lawyer in the energy and infrastructure sector and the construction sector. I've been working in Pakistan for more than 10 years, and for the past 3 years, I've been working in Singapore in a law firm called Raja & Tan Singapore. I thank you, Imran Saab and Tahir Saab, for inviting me to speak on this webinar. So before talking about the deregulation, we should be first looking at why we have the regulation in the first place. So the purposes of a regulation, the key purposes of the regulation are the availability of the product, and that is the uninterrupted supply of energy. We generally call it as the energy security, developed through the policy of the government through two ways. Either it's the energy diversification or the energy efficiency. So the energy diversification is towards the supply side, and the efficiency is towards the demand side of the energy products. The second issue that the regulation aims to deal with is the safety, because of the characteristics of the product. The third issue is the access, and which is one of the most important one. The purpose is to make available the product on affordable, reliable, sustainable, and modern energy for all. And the fourth one is the sustainability. So looking at the regulation, we have to identify that why we are going for deregulation in the first place. Is there anything in the regulation which is hampering competition, which is affecting the improvement of infrastructure and expansion of the capacities and capabilities of the market participants? And we need to also look at, are there crises in the supply of resource because of the regulatory measures taken by the governments? And the last, we talk about the innovation and modernization. What are the different concerns of the oil marketing participants? So the first issue that is that the margins that are allowed to the refineries, to the oil marketing companies and the dealers, they have the margins are not sufficient to enable them to improve their capacities, to improve their infrastructure. So we have the first problem of the disparities and non-availability of sufficient infrastructure. So infrastructure, by infrastructure, I mean to say the sources of supplies, the storage capacities, the pipeline capacities, transportation infrastructure, and the if we talk about the refineries, they have the constraints on dealing with some of the categories of grades of crude oil. So there are problems over the availability of quality products for the consumers. The second problem is the we have operational issues. The operational issues are, for example, we have the port handling capacities issues. We have the problems with the sources of supplies. In the past, we have seen so many times the petrol crisis, and one of the reasons that is attributed is the insufficient storage for the petroleum products. And why the storage has not been developed is because the participants have no incentive to keep the storage, because even if they keep it for a long time, if they keep high volumes of storage, they don't have any incentive because the margins are fixed, and they have to operate on the fixed margins, irrespective of their best performance, their bringing innovation, their market development. So these are the issues that we are presently having in the regulatory framework. So that is the reason why we are thinking of going for a deregulation. But what the deregulation is and what it should be. The concept of deregulation is very, unique and different from different markets. So looking at the first attribute of our deregulation, we're looking at the total or partial removal of regulatory controls. So that means that the government has no role in the fixation of prices. So the prices are determined in a free market through supply and demand of the product. The second way is the second attribute of the deregulation is the market liberalization. So if there are issues in the market, for example, you have the um, the entry to the market has regulatory issues. So you cannot, there are entry barriers in the market. There are, insufficient infrastructure. There are lesser participants, so that there is no fair competition in the market. And so, if we think that the deregulation is a way out which could increase market liberalizations through government policies. So, looking at, for example, the current market situation, the market is fed by two main market participants. The one are the refineries who are sourcing their product from, the imports, which is, around 48% of their use, and then some portion is coming from a very minor portion is coming from the indigenous crude oil produced from the oil fields, and then in the market they have around 51% share. Whereas looking at the oil marketing companies, they are usually importing the petroleum products and contributing around 50% in the market. So the two main market participants are looking at whether they are working on a level playing field or not. So let's talk about the refineries, whether the refineries are able to market their products on their own, or they have to rely on the OMCs. So that deals with their sufficient independence to market the product. Looking at the market itself, like some refineries market the whole product on their own, or they are highly dependent on the OMC. So that defines that whether how much influence they have over the prices in the retail markets. And then we talk about the privatization, the third aspect of the deregulation. And in the privatization, if there are some state-owned or natural monopolies in the market, which are controlled by the state, so what we can do is that we can think of privatizing the state-owned enterprises, so that if there are subsidies through state state aid, or there are some benefits that they owe because of their status as a state-owned entity. So those can be removed, so that they can have a level playing field. Similarly, the privatization can also be helpful in a case where the status actually confers some disadvantage to a state-owned corporation. For example, the private companies have the ability to source their product whatever they want, and they can enter into oil trading business. They can enter into trading transactions to hedge their risk against the sudden increase or decreases in the oil prices. But this may not be possible for certain public sector companies, because they have to undergo every time the PEPRA regulations for for procuring any supplies, whether it be it's the supply of goods or services. So they may be at a competitive disadvantage for that reason. So they don't have the ability to do that in a way that the private companies can do. So the privatization is the third aspect of the deregulation. The fourth aspect, which is one of the most important one, is that the deregulation doesn't mean the control is totally gone to the private sector. So the government loses its control because of the deregulation. The purpose is so that the intervention is not for political reasons, but for running the market in a way that there is no anti-competitive behaviors and practices. To protect the consumer interest, the independent regulators are set up, which do not have the bear the influence from the political governments. They look at the market dynamics, and then they look at the benefit of the consumer and the stakeholders, and determine that whether the markets are working, fairly, whether they are working independently, and everything is being done on the basis of a pure competition, rather than there are anti-competitive arrangements and practices between the market participants to keep the prices at a certain level, or if there is any dominant player in the market. For example, the competition laws set out certain criteria for the determination of the dominant position, and so they may enter into abuse of the dominant position by structuring their prices in a way that they exclude the new market participants or the operations of the existing participants. Similarly, looking at the artificial shortages and the black marketing of the product, or the deceptive marketing, like if somebody is telling that this is the product of a particular quality or grade, but it's not, and it's a deceptive marketing, then the regulators must have to intervene and correct the disparities. So looking at the regime that is currently been in force, the for the regulation of the oil prices. On the top is the Petroleum Levy Ordinance 1961. This allows the federal government to determine the fixed sale price and the prescribed price for the refinery prices, ex depot and ex retail price for the oil marketing companies and the refineries. Similarly, this law allows, under this law, there are certain rules that have been framed for the purposes of regulating how the federal government will be determining the pricings. So the Petroleum Development Levy Rules 1967 allow for different different items that the federal government will be taking into account when determining the margins for the refineries, for the oil marketing companies and the dealers. So I will not go into the details of this because, for example, we talk about the fleet disparities. We talk about they talk about the dealer margins, how much is sufficient, and the OMC margins. But once we are going for a deregulation, obviously, the federal government's role has to be, have to be removed by making certain amendments in the oil products ordinance and the rules. Similarly, there is a role of Oil and Gas Regulatory Authority in the process, and that is not determining the price, but they only maintain and but notify the prices that are determined by the federal government under Section 6(2)(r) of the Ordinance 2002. So we look at the current obligations that the licensees have. They have to be revised so that to some extent the market can be revised. So looking at, I'll not go into the details because of the lapse of time. So the first thing that I'll go is like at 5 from 6. Prohibition of discrimination and undue preference among licensees. So when the market is being operating in an open way, so the licensees may not be, doing any discrimination among themselves. Like the refineries, if selling to the oil marketing companies, they have to have a uniform price for all the OMCs. There should be no undue, preference for one licensees. Like if they have associated companies, they may not be able to, give preference to those companies because of the requirement of their licenses. These are certain suggestions, but I think that because the nitty-gritties, we've been asked to not to go into the nitty-gritties. These were certain suggested legislative changes for affecting the deregulation, but because the conceptual, deregulation is yet to be, it's very premature. So I will not be going into the details of how the deregulation would be implemented and so far as the legislative amendments are concerned.